Hi everyone, welcome to another episode of Ask ALB, a new podcast that covers legal trends and useful takeaways that tackle the latest issues impacting the legal profession today. My name is Julian from Asian Legal Business. We're very excited to do this show. I hope you find it useful for your work. Please note that the content of this podcast is not to be used as professional advice, but just as general guideposts. Asia, one of the world's most economic, dynamic regions, has seen unprecedented developments in competition law, with major developments through legislation, new guidance, and legal precedents. Competition law is a very important consideration for deal planning and corporate compliance for businesses in the region. Now, the COVID-19 pandemic has added a new level of complexity to this compliance process. This episode will focus on managing competition risk in Asia. Joining us to talk about this topic is Kobkit Thienpreecha and Nutavit Sirikan from the Antitrust and Trade Competition Practice Group in Tilleke Gibbins. Kobkit Thienpreecha is the director of Tilleke Gibbins Corporate and Commercial Group. He has been leading the firm's corporate lawyers for over 2 decades. He's currently the partner leading the Antitrust and Trade Competition Practice Group. Nutavit Sirikan is an associate in Tilleke Gibbins Corporate and Commercial Group in Bangkok. Nutavit advises both Thai and international clients on a range of transactional matters, including M&A transactions, technology, and competition law. So let's welcome both Kobkit and Nutavit to the show. How are both of you doing today?
Very well, thank you, Julian.
Thank you.
Great. So there's so much to talk about, when it comes to competition law in Asia, as it impacts, corporate strategies like pricing, supply chain, even day-to-day operations. At a very top level, could you give us a quick rundown of some of the key developments and trends for the region?
Competition law is quite relatively new or esoteric in Asian countries, even though we established the law. Thailand was the first country establishing this Competition Act in Asian, but we are in the verge of learning. We are in the learning curve of the law and developing of the law. In the developed country like Singapore, the enforcement of competition law is quite stringent, unlike Thailand, even though we are still in the early stage of enforcing and learning about this law. Not many lawyers understand what competition law is and how it functions in reality. But the Asian competition law were modeled upon U.S. antitrust law, EU competition law, or OECD recommendations on competition law, and the international cooperation amongst competition authority will facilitate the development of the law in this region. And Kobkit will also introduce the development of Thailand competition law for your more understanding.
Thank you, Nutavit. I would say the Trade Competition Act of Thailand was reformed not many years ago in 2017. The original version was launched in 1999. It was the first country in Southeast Asian country, as far as I know, to adopt the antitrust or trade competition laws. But after the 18 years, the law was not really in effect. Enforcement, I would claim that it was at zero. There were about 100 complaints filed to the regulatory body, which is called the Trade Competition Commission. Out of about 100, no case got to the court. They were dropped by determination of non-charges. There was only one case brought to the public prosecutor, and finally the charge was dropped. So after 18 years, neighboring countries like Singapore, Malaysia, even Vietnam or Indonesia had far ahead in terms of development, educating the public business operators, and even real case enforcement in those countries. To compare with Thailand, finally, the loyal Thai government decided to reform the laws, pretty much keeping the same concept to regulate the abuse of monopoly or market dominant position, cartels, and unfair trade behavior, prohibitive measures. But under the new laws, the mechanism of filing complaint, the budgeting, and the body of the Trade Competition Commission are more effective and efficient. So which led to very fast development since 2017. In 2018, the new Trade Competition Commission was formed. They have budget to do many market studies, and they have launched underlying notification regulations. And in 2019, we start to see some real case determination, and they have been quite responsive to whatever inquiries or complaint filed to TCC. And there's been some good example of enforcement and penalties imposed on those non-complying business operators. Some are on unfair trade practices, and we have not yet seen cartels enforcement, but there's been some development and some regulatory in that part. One thing that we noticed to be in a significant change between the new law and the old version is that under the old version, merger control filing was supposed to be developed, but they didn't get done. So under the new law, they have developed two schemes of filing, which is pre-merger approval, which is something qualifying mergers have to apply for pre-approval from the TCC. And another scheme is post-merger notification, which is something have to be filed within 7 days from the merger date. And since 2019, 2020, we start to see some significant merger high-profile transaction that trigger these two types of merger control filing, and some applications have been filed. Particularly last year, there was probably the largest merger deals in Thailand when Tesco Lotus sold off business to CP Group, and which triggered pre-merger approval filing. And the filing was done in November. Still controversial argument whether determination of TCC was legitimate. So if you ask me in terms of day-to-day operation of all the business operators, I would say they should be one of the highlights new law developments in Thailand, which would trigger compliance duty for all business operators in many sectors, whether manufacturing, servicing, or retail or wholesale operations, because more and more OTCC will issue guidelines, especially under the unfair trade practices, to regulate trade behavior, trade agreements, trade conditions, which might be common and ordinary practice in the old days, but under the new regulation, under the guidelines, is no longer valid. For example, the latest development was the credit terms, which the SME, small and medium enterprise, seem to be under pressure to give longer days of account receivables or credit terms to major operators. So they would get their invoice will be paid quite late, maybe 60 days and on even 90 days. The study shows that SME has been mistreated in the Thailand mechanism. So OTC, Office of Trade Competition Commission, decided to issue this new guideline to shorten or put a maximum time of credit to only 45 days or even shorter, 30 days for agricultural sector. So that would cause a lot of business operators, especially non-SME, when they're buying goods or services from SME, to look at their credit terms, look at their trade practice with SME, because non-compliance will not only trigger civil lawsuit from SME, but also trade competition non-compliance, which can be investigated by or TCC, and which might end up paying quite high amount of fines, up to 10% of their year-end revenues. So that's a highlight of the development of trade competition in Thailand.
Great. So can you give us a snapshot of how COVID-19 impacted competition enforcement in Thailand? How did companies respond to such changes?
Yes, during the COVID-19 pandemic, many governments in around the world imposed a stricter lockdown measure. And can you imagine which services that we need a lot during the lockdown? That is e-commerce business and in Thailand, food delivery. So this is the reason why there is a phenomenal growth of e-commerce business and food delivery service in Thailand, which result in escalating demand, I would say, for such service during the lockdown measure. And consequently, the OTCC, Office of Trade Competition Commission, remain focused on this fast-moving industry I would say there are a couple of complaints against business operators selling products via an e-marketplace platform, and also the increase in price of food delivery services. The OTCC also, monitoring this industry closely, and it results in the adoption of the guidelines on unfair trade practice between digital platform operators and between food delivery and restaurant. The guideline was published in the government gazette on November 23rd, 2020, but it came into force on 23rd of December. I will provide an overview of this guideline. The guideline describes best practice principle and indicate the arrangement, conditions, and restrictions that food delivery platform operators may or may not impose on the restaurant participating in their platform. The main principle set forth in the guideline is that business conduct and commercial conditions imposed by the platform operators on restaurants must be fair, non-compulsory, and non-discriminatory, and must not obstruct another party's business operations. Furthermore, the term and condition of business arrangement should be written in a clear and justifiable manner. It is the first time that the TCC, Trade Competition Commission, had deemed it necessary to intervene in a specific industry by restricting certain unfair trade practices. And, this is an indicative of the TCC greater drive to quell unfair practices using its powers under the Trade Competition Act of CCA. I would emphasize that it showed their willingness to react instantly to new occurrence in the fast-moving market. And also, the TCC continued to put forward stimulus initiative for SME that Kobkit had already mentioned earlier. The SME and agricultural sector are two cornerstones of Thailand economy. And during the COVID-19 pandemic, the government also attempt to provide COVID-19 relief for those two sectors and to protect them from unfair trade practices conducted or committed by a large firm with superior bargaining power. The TCC had adopted new guidelines on unfair trade practice regarding credit terms. I would elaborate on what Kobkit just provided as summary. These guidelines were published in the government gazette recently in June 18, 2021, and it will come to force 900 days after that, which is 16 December this year. The guideline prevent the abuse of market power and superior bargaining power, discrimination, and business obstruction when purchasers set credit terms with the SMEs. And the guideline provide a few illustrative examples of types of conduct that would be deemed unfair. I would say, for example, an unjustified delay in making payment, an unjustified change of credit term or contractual conditions without prior notice, or other unfair conduct or credit term that impose excessive burden on the SME. Typically, our firm, Tilleke Gibbins, has been closely monitoring the progression of the regulatory regime. We will swiftly launch the client alerts and directly circulate our articles to the clients so as to attract their attention to the new laws and regulations which may have an effect on their business. In this respect, we assist our clients in providing constructive and pragmatic legal advice and often in-house trainings to their personnel so that they could revisit their arrangement, trading terms, conditions, marketing, and sales strategies to ensure that they fully comply with the law, including the guidelines relevant to them. Recently, we received a number of inquiries about credit terms, and we also devised a questionnaire for them to obtain the information from their trade partners. That is an overview of COVID-19 pandemic and its impact on competition enforcement in Thailand.
Okay. Do you have anything to add to that?
No. The COVID-19, which hit Thailand starting in February or March last year, and as you know, Thailand has successfully sustained the outbreak of COVID-19 for many months. People were asked to work from home, but because of number of new cases were sustained to zero for several months. But yes, because of closed down shopping malls, the impact would be, I would say, consumer behaviors. People order foods and products from online sources. So that's bringing to successful online operators for food delivery, which Nutavit already mentioned. I'm sure is happening across Asia and globally. In Thailand, food deliveries, there have been 4 major operators. So each of them control quite significant market controls. So choices of consumer are limited. Instead of going out to eat or to shop in the restaurant and supermarkets, now they are limited to order from only 3 or 4. Even outside Bangkok, in the north and in the south, the choices are less. Some province down to only 1 or 2. So TCC determined that it's time for them to step in to regulate and to see whether these operators provide fair treatment, especially to riders, to restaurants. Another impact of COVID-19 would cause surge of the demand in certain commodities, some certain foods and drugs, for example, medical growth, medical masks, or certain anti-COVID substance or food supplements. A lot of people ask whether these have competition elements or not. Yes, Thai government have several branches, not only the Trade Competition Commission. They have the medical board. They have other laws, especially the laws on controls price of goods and services. So the problem is being handled from different agencies and different laws, not really trade competition. So fake drugs or fake medical growths are being attacked and handled by the different regulators. We have not yet seen trade competition element out of it.
Right. So obviously we're living in this new norm today with COVID-19. Can you speak to about the recent competition law and digital technology developments that have impacted supply chains in Thailand?
Yes, we would like to discuss overall of the trend in Asia and then develop the topics to Thailand. Focus. As you can see, the emergence of the COVID-19 together with the digital technology development, we would see more and more interaction of the law in different areas. Many people think that due to the advance of digital technology, we rely more on data protection, but we forget about competition law. There is some interactive when the large digital firms collect your information and abuse the market dominance due to the high volume of big data to eradicate their competitors by means of data analytics. But in terms of Thailand, the new TCA has been aimed to become a new economic constitution of Thailand, which can facilitate free and fair market, which will in turn result in better consumer protection. So 10 provisions of the TCA provide, for example, for collaboration for research and development in favor of the advancement of economics and digital economy, as well as the production and distribution of goods and services. And it is the first exemption that provide advantage to development of digital technology, which could enhance the strength of supply chain in Thailand. And most importantly, the TCA also grant exemption on some prohibition for non-hardcore cartels. I will explain the non-hardcore cartel is the collusion between business operators in the different level. For example, supplier collude with distributors, or manufacturers collude with dealers. That, for example, of the non-hardcore cartel. Or technically, we know it's at the vertical integration, vertical arrangement. The TCA also grant exemption on the vertical arrangement with respect to franchise arrangement and appointment of authorized dealers in recognition of common trading practices in supply chain and distribution of goods and services. We understand that this exemption did not exist in Thailand, but also in many countries like the EU, there is a exemption for selective distribution as well in order to enhance the strength of the supply chain in each local country. The other, when it comes to the underlying reason on this exemption, I would say it was derived from economic principle, where manufacturer, supplier who make certain investment in selected franchisee or authorized dealer. I would say you imagine that they invest the money in decorating the shops. They invest in know-how, how to distribute the goods, how to to manufacture the product or how to sell the product. They also provide support in research, in development. They provide training. That's all the investment that manufacturer or supplier invest in franchisee and authorized dealer business. They also grant some valuable IP rights, trademark, trade secret, business models, and other support. That is the reason why they should be entitled to protect the foregoing from free riding issues. Do you know free riding issues? It means, for example, the platform who has no brick and mortar shop. So they have very low cost in the operation, and they can reduce the price a lot. And then we, as a consumer, we want to try a product. We go to the brick and mortar shop, but we don't buy the product from brick and mortar shop, but we in turn purchase the product from the e-commerce platform. That is the free riding issues, and it's just general economic principle that the Competition Authority of Thailand also recognize this issue. In addition, for this exemption, why the intra-band competition may be restricted by the utilization of this exemption, for example, market location or retail price fixing. But there is a foreseeable increase in interbrand competition among different brands and competitors in relevant market, because business operators in the same brand do not need to compete with each other, and they have power and resources to compete with business operators from different brands. That is the significance of exemption on non-hardcore cartel in some aspects. The distributors and dealers usually rely on supply from products from supplier manufacturers, and thus practically suppliers or manufacturers usually enjoy superior bargaining power over the distributors and dealers. The provision on unfair trade practices also enshrined in the TCA, and it will interfere with the unfair conduct and discrimination and abuse of market power, superior bargaining power committed by the suppliers and manufacturers in this respect. In brief, it could be said that the TCA is a crucial legal instrument to invest competitiveness and efficacy of entire supply chain system in Thailand.
I would supplement that recently, within a week, there's some study from the TCC which indicate that they have their eyes on e-platform, which might seem to have abused or used as market powers, being an online shop to get into the advertisement. You probably heard about what the trade competition authorities in Europe, in Australia, is doing with Google's, with YouTube. So the trade competition are looking at these angles, especially the popular online platform, that they themselves, instead of use the traditional publishers and advertiser mechanisms, they themselves seem to limit or reduce competition in that areas, and they do the publishing and advertising by themselves. So they corner the advertising market, because they are the e-market operators, sometimes they are the vendors or merchant themselves. So with consumer behaviors and big data, and they use that data to track consumer behaviors and propose or regulate how the advertise being done on their platform by themselves. So that would limit the traditional publishers and advertisers to enter to the market.
Right. Has there been any major developments for merger controls in Asia? Can you also provide us with some ideas on how to coordinate multi-jurisdictional reviews?
Yes, there is a significant development for merger control in Asia. Due to the economic downturn which stemmed from the COVID-19 pandemic, there has been a high tendency for horizontal, vertical, and conglomerate merger globally, including in Asia region, so as to enhance the investment capabilities, cash flow, liquidity, and research and development collaboration to survive the financial hardship, I would say. We have realized that the competition authorities, including the OTCC, Thai Competition Authority, continue to keep an eye on the anti-competitive merger, hostile takeover, and market concentration, together with the possible coordinated and non-coordinated effects after the merger and acquisition. It's we have received some inquiries about the due diligence periods in the merger and acquisition because the party had not merged the business together yet, but they had to disclose some information for due diligence period. Is it possible that the competition authority also monitor the possible cartel, I would say, and collaboration between the would-be merged party during the due diligence period? And it remain questionable as to whether or not the non-disclosure agreement is sufficient to safeguard them from the allegation of cartels. That is the development of merger control in Asia, but because it's not only about merger control regulation, but it also other substantive provision of competition laws as well. When it comes to the filing and merger control in Thailand, the merger control provision under the TCA impose pre-merger approval and post-merger notification upon qualifying M&A transaction. I would like to explain that the TCA sets out a dual merger control system, as I mentioned earlier. That is pre-approval, which is required for the merger, which result in a monopoly, only one business operator left, or business operator having a market dominance. Those business operators enjoy a substantial market share, let's say 50%. They have to submit application and require document to the competition authority to seek approval before they can merge. But if it does not result in monopoly or market dominance, they have to consider whether or not the merger transaction will result in a substantial lessening of competition. Let's say they have a sales turnover in the previous year in the relevant market of more than or at least 1 billion baht. They have to report the result of the merger to the competition authority within 7 days of completion of the merger. I would say that Gibbins have been entrusted by a number of international clients to advise on merger control regime in Thailand, but most of the transactions are worldwide or involve many countries in the region. And the transactions have been effected at a parental level overseas, but not Thailand. However, the clients have business activities either through their local entity here, through agent here, or through distributors here. They are subject to the merger control regulation in Thailand and similar to those in other countries as well. On account of the context of merger control regulation, I would say several offshore cross-border acquisition could easily trigger either filing duty under the TCA in Thailand or under the competition law of other countries. Therefore, the merger filing is required in multi-jurisdiction. Is it really challenging to collaborate with the clients or coordinating local counsel owing primarily to the time constraint of the closing? Because the client usually set the closing date. But if it's subject to pre-approval, we have already fall within the time constraint because we have to get a clearance from competition authority before the closing date that's set by the parties. That is the pre-merger approval. Likewise, if the merger transaction is subject to post-merger notification in Thailand, there is only limited time frame of 7 days. 7 calendar days is not 7 business days for post-merger notification. Recently, we have succeeded in pursuing the post-merger notification for the merger between two behemoth global freight forwarding companies which have operations in more than 100 countries around the world. But we can get it done within the time constraint of 7 days. And similar to other filing requirements in other countries, the TCA require a lot of information and document, especially the information about market share, sale turnover of the merging parties. It's not only local, but worldwide, as well as a certain degree of market research and analysis. One of the useful techniques for in-house counsel handling merger filing is that they should initially work internally with their finance and marketing team to prepare information about market share and turnover of their local business, and further conduct surveys to obtain the depth of knowledge of relevant markets and key players in respective relevant markets. And they can easily share the information with local counsel when they need to pursue pre-merger approval or post-merger notification in each country.
Anything you'd like to add to that, Kobkit?
No, it's quite complete analysis of merger control.
Okay, cool. So finally, is there any final advice you can give our listeners on how they can spot and manage multi-jurisdictional competition risk in Asia? Any key takeaways for our listeners?
Yes, I would recommend that prudent business operators in Thailand or around the world, especially in Asia countries with competition law become more and more important and the enforcement is more stringent. It should remain up to date and prepared for stringent enforcement of these measures to ensure that they remain compliant as the situation evolves. That is, contractual term, business conduct, and trade practices, whether orally or in writing, should be reassessed and adjusted if necessary to ensure full compliance with the law. Prior to launching new products or initiatives or modifying existing terms and conditions that may adversely affect other business operators, competitors, and trade partners, they should seek legal advice from their in-house counsel or local counsel to ensure that they are still fully compliant and effective. It will be an effective management of legal risk as well. On a side note, I would suggest competition policy in many countries around the world may have been influenced or modeled upon the US antitrust law, EU competition law, or OECD competition law framework, as I mentioned earlier. But the policy may ultimately vary according to the dichotomies of nature of local market, ordinary trade practices, and objective of implementation of the law. So we'd like to recommend the audience, business operators and in-house counsel to bring local counsel on board or seek legal advice from them, particularly when there are foreseeable risk of violations of the law in terms of pricing strategies, discount and rebate schemes, potential foreclosure, and other anti-competitive conducts.
I would like to add that there's only a few concepts under the trade competition. For example, abuse of market dominance. If you are general counsel of your companies, you would know your market position of your own companies. Thailand threshold is about 50% if you are a single operators, and if you must have sales revenue of 1 billion baht, that's about 33 million US dollars. So if you're not that size, you don't have to worry about abuse of your market dominance because you're not categorized as market dominance operators. So the only two schemes that you should be aware of and maintain compliance on a continuous basis would be cartels. I'm sure that you have internal controls and good governance policy not to collaborate with your competitors on price or on market allocation. But sometimes you do that without intention. You happen to share your price sensitive or sensitive information to your competitor, to your trade partners. So be careful and be aware of that. Under the unfair trade practice, there's a catch-all schemes which covers variety of unfair trade practice, whether with your trade partners or whether an attempt to block your competitors into the market. So that is something you have to learn over time and discuss with professional legal counsel. What I know is that OTCC about to change that scheme after 4 years of use. The thing is time to develop what should be categorized as unfair trade practice by determining trade condition with your partners which block your competitors into the market. So that's something you have to learn over time.
All right. Okay. Kobkit and Nutavit, thank you so much for those insights. It was really great having this conversation with you. With that, we've come to the end of today's episode of Ask ALB. I'd really like to thank our guests, Kobkit and Nutavit from Tilleke Gibbins, for joining us today. Okay, where can our listeners find you if they have any questions pertaining to the issues we spoke about today?
Well, our website is quite informative. Our BD marketing teams has regularly published our client alert and good articles. Again, Nutavit and I together leading our antitrust and trade competition practice. We on a regular basis being on top of the legal development. We issue client alerts we organize public seminar through our own platform or other platforms. You can log into www.tilleke.com. You can log into my profile or Nutavit profile to see the list of activities or the publications that we have made. Or you can choose to send our email to our address. I will keep your contacts, and I put in our directory to make sure that you receive regulatory updates and client alerts.
All right. Both Kobkit and Nutavit will also be speaking in greater detail about competition law, practical guidance for the prevention of anti-competitive conduct in the upcoming ALB Virtual Thailand In-House Legal Summit happening on the 22nd of September 2021. So links for complimentary tickets for in-house counsels can be found in the link below. With that, I'd like to thank everyone for joining us today. Remember, Ask ALB can be streamed on iTunes, Spotify, or Google Podcast. And we'll catch you in the next episode. Thank you, everyone, and thank you to our guests.